Again. Welcome everyone. Sorry for that little technical mishap. And today we're going to be covering the main news, which is the 70 billion that ICE is getting. Now, of course, we could talk about the Rhode Island judge ban on the 39 countries now being lifted, but they're probably going to appeal it. We're going to talk about adjustment status. And then the success story we're going to cover is about a 30-year-old kid, I think it's a lady, who we were able to freeze her age and bring it down to under 21. So she was able to get the green card with no interview. The biggest thing is she came in as a tourist. Adjusted status, was 30 years old. We were able to freeze the age back to 21, use the old CSPA memo, and successfully got it. No interview, green card in hand. That is what we are going to be covering today. Okay, so today the main news that we're going to cover is the 70 billion. And I want to put it in perspective because I just see so much misinformation on both sides. The first thing I want to tackle is that this 70 billion that they received is not outrageous. It is not as outrageous as what the media is saying. And it's important to know things in context because we need to predict what immigration is going to be like next year, 2 years from now, 3 years from now, 4 years from now, right? That's the thing that's important. We want to know what the future is like. And this funding really tells us a lot about what the future is like. So let's start with some basic premises. We know ICE's annual budget, historically, past 10, 20 years, has been about $10 billion, okay? And it has stayed that way even though inflation has gone up. So which means they're actually getting less and less buying power. That's the first thing. The second thing is we also know ICE has been greatly underfunded, just like every other agency, right? You're no surprise there. The government doesn't pay their employees very well. And so ICE is greatly underfunded for the past few decades. USCIS, CBP, and consulates, they're all decreasing in their funding and their pay and stuff, their staffing. And so in the past 10 years, that's been what the situation is like. Now, suddenly last year they got 70 billion and now seemingly they got another 70 billion. It seems like that's outrageous, right? And I've talked with a lot of senators about this particular issue when I went to Capitol Hill this April and we were discussing it. But when you actually put it in perspective and know exactly what they're trying to do, it's like, oh, that's the intent, that's purpose. Let's break it down a little bit more. But before I actually break down the numbers and go into the more premises, I'll answer some questions first.
So the H1, 100,000 feet, struck down initially. The government has filed an appeal today. So what do you think the chances are of a stay or a successful appeal in the First Circuit?
I think 100,000 is it's a pretty drastic number for the government to put on it. I think it's going to be litigated for a long time on it. So I think it's going to carry through probably even until next year's H-1B. And for all intents and purposes, once that's struck down, the next executive order can go out and it would apply again, right? So if you are an applicant or if you are a practitioner dealing with this issue in the H-1B space, I would still prepare that a change of status in the US for H-1B is a much higher chance. If you're overseas and you want the H-1B to come into the US, the chance of you actually filing H-1B, getting approved, going to the consulate, getting a visa, and coming in this year, next year, the chances are slim. Courts are going to battle it out, but the next executive order can apply again. That's my read on it.
Is adjustment of status from B1, B2 to F4 still possible under the new policy?
Is B1, B2 change of status to F4 still possible? Is that what you're saying?
Mm-hmm.
B1, B2 to F4. I don't see why not. Again, it is discretionary, but do a really good case, make a really good argument. You were here on a tourist, but your spouse got into a particular school. The whole family decided to stay. You guys have enough funds. You guys are not, going to work illegally. This is the career intent. This is what you want to do. They already got the F1. I want to stay now, right? You want to prepare that. Or you came here, got married, and so now you want to stay. But you want to do additional argumentation. The adjustment of status memo doesn't actually apply to change of status, which is very interesting, right? The adjustment of status memo would ask the question, why didn't you go back to your home country to get a proper visa to come back in? Change of status doesn't require that. So I might not voluntarily fight that battle unless it's requested in a request for evidence.
N600K,
Yes.
is oath ceremony still being held at LA Field USCIS office?
Great question. You might be a client in the UK tuning in. I don't know yet, right? We still have to go check this afternoon to find out more details. And if you are that client, I'll let you know either later this afternoon or tomorrow morning.
Okay. Are asylum decisions still happening? My interview was on March 12th of this year.
Asylum interviews are definitely still happening. We don't do asylum, but I know it's definitely still happening.
Any thoughts on 751 processing time?
I have a lot of thoughts on it, and we made a lot of videos on it. If your question is it fair that they take 3-4 years? It's just so hard for government officers to adjudicate what case is real, what case isn't. So using time, delaying things is one of their best ways to test things. And so that's what they do. Intentionally, unintentionally, that's part of the process. There are cases that get approved within 3-4 months. If you have certain security clearances, we have seen cases move a lot faster. So for your reference point.
My mom is the principal applicant. So this is for the B1, B2 to F4. Mom is the principal applicant for the B1, B2. She isn't that skilled is the issue. She's done her high school. She has family there, her mom, and she has 2 children who will go to school.
So B1, B2 to F1?
To F4.
So dependent? So the husband is the F1? So husband is studying MBA, master's degree, PhD, something, and then the wife wants to stay with the husband, so wants to change to F4. Yeah.
So yeah, but
well, I mean, it should be F2, right? F2 is the dependent for a student visa, unless we're talking about like a family petition for adjustment of status, which is different.
Okay. Do you think USCIS officers care about this? Oh, N600K. Do you think USCIS officers care, but just too much work to handle?
Do I think USCIS officers care, but there's too much work to handle? That has been true probably for the past 10 years. Now, I can't say universally. There's definitely officers that are burned out and just jaded and don't care anymore. That's definitely true. There's good days and bad days. But a good majority of them, it's not easy to get this job. A lot of them do it because they love the immigration process. A lot of them are immigrants themselves. It takes 2+ years to do a background check. They have to review everything. They like going to federal building. They like reviewing. A lot of them have worked in the immigration space. A lot of them, well, not a lot of them. A few of them have been our interns, our staff. They graduate and they now go work for the government. That's fine, right? And I want to say most of them are good people. And so they do care. But the work is crazy. There's just so much that they get thrown at, and without training, without resources. So feel bad for them.
How long is renewing I-90 green card processing?
We have seen some cases take like over a year, but the past few years, we also see some cases take like 3-4 months, like super miraculously, but it definitely could take a lot longer. Plus, they're adjudicating it much more stricter since starting last year.
Any update on the 75-country visa pause?
Not the 75-country one. The 39-country one was litigated, and the Rhode Island judge declared it unconstitutional. So it's going to go through the appeal. So we'll see how that goes. But just like the H-1B thing, after all the appeals, even if it's struck down, probably the next executive order will fall into place.
Have you resolved a scenario where the client has a U.S. passport issued by state, but USCIS denied the N600?
I believe so. Let me really think about it. Got the passport, but denied N600. Yes, I've definitely seen that before. I've definitely seen passport and don't get the N600, don't get the N400. Well, not usually the N400, the N600. It's much more rare the other way around, where you get the N600, but you don't get the passport unless it's for some custody reasons. And the reason for that is because for the past 10, 15 years, 2 different agencies are issuing proofs of citizenship. Then N600 has to go through the N600 requirements to give you the naturalization. And then the passport agency gives the passport. And you can apply to each of them independently of the other. And they have different personnel, different training, different requirements. Similar immigration law, but not exactly. And I can say almost affirmatively, in the past, going to get the passport was significantly easier than dealing with USCIS. And so a lot of people have done it that way, got the passport, and don't sweat it. That's proof of citizenship. They don't even need the N600K. They don't need a certificate anymore. And that has been sufficient. But I want to say 3-4 years ago, I started seeing the federal building, not just in LA, but across the country, become increasingly strict, just like USCIS, issuing requests for evidence and not issuing you the passport. So it is certainly possible, and which I actually have seen, somebody can get the passport, but do not get the N600.
Do you know if duration of status is still being finalized for F1, like removing the DS?
That is in process. I don't think it is finalized yet.
Okay, for this B1 to F4,
yeah,
we have the B1, B2 currently. Priority date is current for the filing chart. We want to do AOS to F4. The I-130.
Got it. So
my mom is a principal applicant. She isn't that educated. Will this affect the case?
If your question is, my mom is not that educated, will that prevent me from adjusting and getting a green card? Loosely, because your education level is not directly a requirement or a bar to getting a green card, right? If you're, not educated at all, you could still qualify for the green card. You could be a PhD and you could still get denied. So it is not necessary nor sufficient. However, maybe where it's linked to is more so the idea of, are you going to be a public charge? Once you do the adjustment of status, once you try to get the green card, you and the entire family, right, mother and all the kids, everybody's going to get the green card. Who's going to support them? It's expensive being in the US. So the sponsor will now have this additional burden of proof to prove that they have enough sufficient income. That is where the education is most closely tied. Because if she's highly educated and she's self-sufficient, he has a lot of tax returns, then more likely or not that she's able to work and self-fund. So that's where the education thing is. Now, obviously, the adjustment status memo that came out on May, was it 11th? 21st. That obviously will play into it. Did she lie to the officer when she came in? Was it really for tourism? Did you do any tourism? Why don't you go back to your country? What's so important for you to be in the U.S.? How does adjusting in the U.S. beneficial to the U.S.? You have to be able to answer these questions and prepare for it, right? And again, the application process could be like a year before you do an interview. So a lot of things to prepare. But the education level is not the thing that I will be worrying about.
So following up on that, if AOS does get denied,
yes,
after the interview, do they cancel the case completely, or do they have a chance to go back to the home country and do it through consular processing?
They will always be able to go back to the home country to do it. However, if the adjustment of status was denied and she is labeled with fraud and misrepresentation, then the adjustment overseas will have to have a waiver, and that could delay the process by several years. So best case scenario, you get the green card. Second, denial, but no fraud, just preferably you go back to the country, then you leave. But just on that note, if you do get that denial, right, if your case is the first one in the country where it's denied purely based on this May 21st memo, I could tell you there's probably over 100 attorneys across this country that is willing to take on this case to sue the government, right? And there's so many people already preparing it, us included. So just know, And so if the litigation is in process, you don't have to leave, right? Obviously, you could, but then you can't sue the government anymore, right? But if you choose to stay, there's plenty of firms that are willing to sue, nonprofit and normal companies.
While waiting for your new green card, is it safe to travel with 797 proof card notice? And 551 stamp?
Advanced parole.
Yeah,
advanced parole or 551. It's totally fine to travel. if it's a short duration, if it's innocent, if it's not like if you don't have any other criminal records, if it matches with the intent of you filing the 45, the customs will not give you that hard of a time.
Can senators or Congress really help expediting age out cases and like actually push things through?
Good question. Yes. So there's a lot of nuance to this question, but if you qualify and your age is almost, about to age out and you're really concerned, every agency already has their own internal memo pressuring them to prioritize it. That we've known for years. And having a senator or congressman follow up and say, hey, by the way, my constituent, they're about to age out. They only have a few months left. Please adjudicate this case a little bit faster. Usually it brings it to attention. And which is very needed in this time because the officers just have too many cases, so they don't understand how to prioritize.
So for this N600, denied. Okay, so someone has an N600 denied due to missed appointment,
Yes.
but has a U.S. passport. How would you appeal this mismatch? And would you be able to help?
N600, unlike all the other type of cases, you have to file a motion to reopen. You can't just refile N600. So you have to file a 290B. And then once you file the 290B, it's with that original office. And what you want to do is you want to go back to that office in person to talk about it, right? And that's what we're doing. And I'm very hopeful. Today we're going to get a successful result. We'll see. We're definitely going to be talking about it and filming it next week. Hopefully. Well, at least an update because the case might not be resolved until a few months from now. But at least we'll see what happens. But that's the way to do it, right? Go in person with the 290B, talk to the officer about this case, let them know the urgency of it, and hopefully you could get a faster adjudication.
They're talking about denial of asylum cases filed after 1 year of last arrival. So if someone is on a valid status, can they send him to court or just deny his asylum?
Once an application is denied, whether it's a change of status, adjustment of status, asylum application, if you are out of status, after about 30 days, you will almost automatically now get a notice of intent to appear to go to immigration court to be deported. So let's say you came in as a tourist, you filed change of status was denied, your tourist status is already, out of status, you stayed here for too long, you're going to get an NTA. We have some clients do that and we have to go to court to get it closed, even though the client already left the US. Other people, let's say you're doing H-1B, didn't get selected or got denied, but then you overstay your student status, well, now you can get an NTA as well. And so whatever status you're in, if you file and it gets denied, if you're out of status, your I-94 is expired, you're gonna get that NTA. So that's fairly certain. That's what you should prepare for.
Their status is valid.
But if their status is valid, then chance of you getting an NTA is very, very low.
My son paid for OPT premium processing and was on the list of the 39 country.
Okay.
So USCIS pause. He's still waiting
Yeah.
for his OPT after the pause lifted. So is USCIS starting to process them now?
I would definitely put a call in with USCIS talking about this, escalate it to tier 2, just get more people's attention on it. Now, if the case is appealed, it's probably going to still stay, paused. I mean, I just don't foresee the government not appealing it, right?
What reasons have expedite requests been granted in the last 2 years that you've seen?
What kind of expedite request? I mean, there's so many, right? Advanced parole expedite request, reentry permit expedite request, consulate interview expedite request, parole expedite request, 551 stamp expedite request, and 400 expedite request.
N600K.
Oh, we do very little N600K. We do it maybe once a year ish. Age out is the main reason for N600K, but some people, like the one we're doing today, is because of travel reasons. So that's like the other major reason.
Can you renounce U.S. citizenship and then reclaim it later without filing any new paperwork?
I don't believe so, but we've never done it.
And what's the longest time you've ever known to take a change of address to take effect and change the field office?
When's the longest time? I'm assuming you mean, well, if you mean I moved and I didn't file the AR11 change of address until years later, that happens all the time. So years, like you're supposed to file it like within 90 days or something, right? But most people don't, and most people forget, and technically you could be fined on it, but some people wait years. Some people do it immediately. So, yeah.
I'm a Canadian citizen. I was born in Iran. My dad petitioned for me back in 2016, F2B. I-130 approved 6 years ago. Had my interview in Montreal in 2024. Been on admin processing for 25 months. Should I file a mandamus? What's my best course of action?
Because mandamus really only helps you if the case was filed in the U.S., adjustment of status. Consular processing, I've never seen that work. Not impossible. Chances of it working is just very, very low.
So what's the best course of action?
The best course of action is continuing to have senators, congressmen push this case for you, continue liaison with the direct consulate to try to get this case moving forward. That's the only way.
Okay. Oh, what I meant is, if you change your address, how much longer could your case take to be decided on? Or like, how much would that really delay the case?
Oh, how long will it delay the case? I mean, worst case scenario, it could delay it by a year, right? Because you change address, they have to pull the file, things are getting transferred manually, it gets lost in the shuffle, nobody's looking at it. I mean, this happens on a normal non-transferred case, right? You file a case normally and then 15, 20 months goes by without anybody seeing it, like, oops, and then they find it. So, so if you do a transfer and things have to do it manually, especially in 600K, it could definitely be a long time.
After you renew your green card, how long to wait until you start your citizenship process?
The rule is 5 years. So, but if you get married to a U.S. citizen, it's 3. Yeah.
That's after you get your green card, right? What about just renewing the green card? Does that change?
No. So you could do it immediately. You could have done it, 7 years ago, 5 years ago.
Is USCIS ombudsman still helpful?
Well, okay, so I'll tell you hearsay. Okay, there's a hearsay evidence. Ombudsman was shut down under the White House. I think it was an executive order, but it was shut down. It was obviously very disappointing. Everybody was really upset. One of my colleagues, through their nonprofit in San Diego, sued to say that actually violates, the constitutional law, and you're supposed to have it, and Congress authorized that you just can't shut it down. And it worked. And so they opened it up again. But after opening it up, are they really doing what they are intended to do? Or is it just a bunch of contractors just passing on a message? And so it's actually useless. From hearsay evidence, from the attorneys that did the lawsuit, that knows what's going on, they're telling us that that's what it is. I haven't tried the ombudsman for a while now, since it was shut down, so I can't tell you if it actually works or not work. I am not aware of that many crazy success stories where the ombudsman did put their neck out and actually save the case recently. So I'm more inclined to believe what I heard from the people who did the lawsuit. Now, is it possible that it was just like a lip service for first few 6 months, and then eventually they're going to ramp it up so that it's a normal ombudsman again? Maybe. How much can ombudsman help even before the government shut it down? They were mainly alerting high-level cases where there's major trends. Individual case service was still much more limited, so it's not like a perfect solution. It's just one additional pathway. Hopefully that helps and puts things in context.
So government's appealing the H-1B 100,000 judgment. What do you think the chances of that appeal being successful?
I don't know, 50-50. I mean, I think government, I feel like the White House has a lot of leverage. They've thought through this very carefully. It's a consulate thing, so I feel like they're very well prepared. But again, you know, the litigation team striking it down is also really strong. But this is also just a district court appealing it. It's going to be now a constitutional power grab. Does White House have this authority, or does it strictly is a congressional authority, right? And I'm more inclined to think it should be struck down, because if the White House, whoever's in charge, could just say, you know what, I'm going to slap a fee to whichever visa, that completely nullifies almost all immigration law, right? But at the same time, they can argue, well, all of immigration should and is fall into the foreign powers anyways. It shouldn't be a U.S. domestic thing. And it's already leaning that way, right? Like immigration judges, they're not Article 3 judges. They are part of the executive branch under the right authority of USCIS. So, CBP, ICE, they all listen to the government, the White House. So why not this decree, the 100,000 feet, right? And so I think reading through it, thinking about it a lot, I'm still really at 50-50. But even if the judges rule that it is completely unconstitutional, you can't do that, knowing what Trump has done in the past couple years, first term and second term, he's just going to come up with the next executive order, right? Look at all the tariffs. Oh, you strike it down, I'm going to come up with the next tariff, right? So he's going to try to get his way. And this is his second term, mind you, right? He has a lot of power. He doesn't care about the third term. Well, maybe. We'll see.
So for this F2B, I-130, admin processing from Montreal for already 25 months. How much longer do you think the consul processing could take if you just write it out?
We've seen admin processing take like over 5 years. So there's no end to how long admin process can take.
And they said they called the congressman in California, and they said they can't do anything because I was born in Iran, even though I have the Canadian passport. Confused, I don't know what to do. Some lawyers are saying file it, some lawyers are saying don't file it.
Ask the lawyers that say file it what they think the success rate is, and has it ever been done before, right? So if no one has it done before and the success rate is very low, then I think the people who are saying filing it and the people who are saying don't filing it actually agree on the same stats, right? So I don't think you should listen to attorneys. I think you should get facts and make a determination on your own.
Do you think the Boston judgment on the H-1B, 100,000 feet, will affect pending cases in California?
No.
Okay, hard no. I did my interview a year back, but I had a pending court case. It got dismissed, but I still haven't heard back.
Okay, wait, hold on. I want to go back to that hard no, right? So there is the small percentage chance where you file a change of status H-1B in the U.S. and a USCIS officer says, nope, then I will approve the case, but I'm not going to approve the change of status. I'm going to modify your form and I'm going to send you overseas, so you have to do the consular processing, thereby making you pay the 100,000 fee. I personally have not seen that happen. I know that could happen. I know some rumors of it happening, but I haven't seen it. But theoretically, that's possible. This Rhode Island case would probably deter that action. So, and therefore, I think if you file the change of status in the US, I think it's either just approval or denial. I don't think they're necessarily going to take that action of changing it. But that's my opinion.
Oh, they meant the pending global nurse force.
Oh.
Regarding the H-1B 1,000 feet.
I have no idea. Yeah, no, I don't know.
Do you think in a few years the U.S. will have a shortage of skilled immigrants and may open up the rules again? For example, nurses, doctors, etc.
The U.S. has always and still is in short supply of a lot of professionals, nurses, doctors, farm workers. There's a lot of people that's actually extremely needed. Not just the farm workers themselves, but the skilled labor of supervising the farm workers as well, right? And this administration and the immigration policies have made that need even greater. And with the advancement of technology and our GDP and all the things that's happening in the US, that need will continue to grow. The question then becomes, what is the solution? What immigration policies that would make sense, that the public can stomach, and that will be beneficial to the US economy and US welfare as a whole to implement to solve that major labor shortage? Is it a massive immigration reform, or is it patchwork immigration reform that will solve particular needs? Or is it just a policy change by USCIS? Whatever the solution is, it is not a simple, right now we don't need it, later on we need it, so we open or we close. Immigration law is far too complicated as it's just an open door, closed policy. It could be non-immigrant visas, it could be immigrant visas, it could be exceptions, it could be paroles, it could be partnerships, it could be open up new visa categories. There's a lot of solutions to solving labor shortages in different fields, but it depends on what the politics are at that time, right? And it depends on what the US needs and what crisis the US is going through. So hopefully that's a much bigger perspective.
Does EB3 green card holders, do they have to be continuous residents in the US for 3 years before citizenship?
The only people who can get citizenship by being green card holders for 3 years are people who are married to US citizens. So if you got your green card 3B3, great. If you're married to a US citizen, you can apply for citizenship faster. But if you are not married to a US citizen, you should wait 5 years, just like every other category.
And has the processing time for current EB3 applicants who are still waiting in the visa queue improved?
No. In fact, EB3 is probably not going to be getting faster anytime soon. But no, that's a conjecture. I don't want to say that. It could jump up too, because EB2, EB1 will jump up significantly.
How long are you allowed to leave the country with a green card without risk of losing it?
Without risk of losing it? No risk at all. 3 days. I think 3 days is very, very safe.
What about acceptable risk, very discretionary term, but could you speak a little bit more about how long is too long?
Yeah, well, it's up to the officer's discretion, right? And so if it's short, innocent, casual, if it's like a vacation in the Bahamas, if it's like, you're going on a, trip, a week, or 2 weeks, you're going to a bachelor party, those are all what 90%, 99% of people do. Then you're fine, right? You have a small suitcase, you're going through a big airport terminal, you've done this plenty of times, if your profile matches 99% people, then that's fine. The moment you leave over a month, suddenly that's not what most people do. You leave for the 3 months, 6 months, suddenly you're crossing a big red line, right? If you leave for 3 months at a time continuously, and then you only you leave for 3 months, you come back for 2 days, you leave again, they see the past 10-year record, it suddenly becomes more and more risky, right? But if you're saying super safe, be like the 99%.
I just got EAD, but my case is admin closed. What's next?
It's rare to get admin closure. If you got an admin closure on USCIS, that's usually not a good sign. That usually means you're going to get an NTA or you already got an NTA. If you got admin closed by the court, that's usually something to celebrate. And at least you don't have to worry about being deported anymore. So depends on who's closing your case.
Administratively close.
Yeah. By who, right? If it's by the court, great. You want a big victory. At least you're safe for now. If it's by USCIS, it's like, dang it. What you tried to apply for didn't work. They closed it. Now you have to fight it in court.
Have you heard of approved NIE for the 75 country pause?
No. But I'm not that in touch with all the NIEs that are being filed.
If you sponsor family for a green card, there's a child who is over 21 by the time the visa number is available. Can the over 21 child still get the green card?
You have to use the Child Status Protection Act, CSPA, and you have to qualify based on that formula. And so if by the time the child's age is already over 21 when the visa became available, then it depends on how much time the case was adjudicated. So if the case took a year or 2 years to adjudicate, you have the potential to be able to bring back that age. And so that's like the old CSPA law. The new CSPA law that got now reversed made it even broader because now you could use different schedules, and sometimes that buys you an additional 6 months, or in this case, it was able to buy a client like 10 years of extra time, which I'll go into. Right? Today's success story is about CSPA, but it's double success story because the client came in as a tourist and then adjusted status, and we use CSPA, and the interview was waived, and there's no RFE, and the case is approved, and now she's like 30 years old. So it's pretty fun. But CSPA is definitely getting harder.
Should someone who they had their interview, case has been pending 6 months post interview, should there be like an inquiry about that? Is that normal?
It depends on what kind of case. 6 months is still within reasonable time to USCIS. A lot of cases do get approved within 1 month, 1 week of it being approved, but they are dragging it out a lot more. Usually after the year mark, after the interview, that's usually when you want to sue, the mandamus action. So it depends on how well the interview went, and you can always do the inquiries to try to push them, right? So 6 months, push them once, 9 months, push them another time, get to 12 months, litigate it.
NTA received, not applicable for VAWA, asylum, T, or U visa, and I'm not married. How can I stop this?
We don't do removal defense. We don't specialize in it. I think that's something to really, brainstorm with a removal defense immigration attorney. However, maybe I could try to suggest look into 42B, cancellation or removal. But with my limited knowledge of removal defense, these are the solutions, right? So you mentioned already a lot of them. One of the last ones is just a cancellation.
Is a U.S. citizen able to sponsor someone from Guatemala?
I believe so. We don't do a lot of cases from Guatemala, so but I believe so.
Do you think the Boston H1 judgment was made with solid legal reasoning from your expertise?
Yes. I think both sides make a strong, good case. I think this is one of those. I think unlike Trump's first term, where everything he did was like struck down because it wasn't well prepared, I think everything that's done now, a lot of the things that he's doing might seem completely out there, but it has pretty strong legal footing. But at the same time, he is really pushing the boundaries of everything he's doing, and so there is also a lot of legal footing to argue against and try to strike it down. I'm just saying, even if it is struck down, that doesn't mean it was completely whimsical. He could just modify it so that makes it stronger, and then now he can do the next executive order where it's almost, bulletproof.
So this post-interview, it was family-based AOS. They had their interview, and now it's been 6 months pending.
Yeah.
Normal, worth filing the inquiry. What do you think?
It doesn't harm your case to file an inquiry. So 6 months, file it. 9 months, file it. 12 months, then consider maybe litigate it and spend the money to do mandamus. But maybe have a congressional inquiry on it, right? Every 3 months.
Can you ask to leave the U.S. with a green card for longer than 3 days? Basically, get permission so there's no risk to lose the green card.
Absolutely. That's what the reentry permit is for, right? So when you file the reentry permit, during the validity of the reentry permit, you can be out of the U.S. So that's why we have some clients who've been out of the U.S. with a reentry permit for like 3 years and then come back, right? So if you want to be safe, you definitely should apply for a reentry permit. Now, if you're going to be instead of 3 days, you're saying, oh, 30 days. But now you're getting like, I'm kind of worried that they'll, scrutinize me. But if you file the reentry permit and you have the receipt that you did the biometrics appointment and everything, you can show like, oh yeah, I did this, I paid for this. And, that's why I didn't abandon my residency. Now, if you file the reentry permit and then you leave for 6 months, 9 months, and then you come back and you don't have your reentry permit in hand yet because reentry permits are taking like 16 months, the officer might not recognize that, right? They might say, no, unless and until you have your reentry permit, I don't recognize this. So we've had some clients have done that and they get warned very severely, even up to twice. And that's why we're almost advising our clients, if you're going to leave for more than 3 months, 4 months, 6 months, just don't come back until you have your reentry permit in hand.
If a USA company wants me to work in the US temporarily, what visa process would be used and how long would that take to get approved? Can it be renewed, etc.?
Yeah, there's a lot of visa categories. But I'll just name some off the top of my head. But I think ChatGPT can do a much better job, right? Because you could feed in your information and they can like analyze it. But there's the B1 visa where the overseas is sending you. There's the E2 visa if you're like a treaty employee, E1 or E2. There's H1B. There's O1. There's what else is there? Yeah, I think those are H1B. Yeah.
I got a green card by accident via USCIS error. Now I'm a nurse. Can I adjust to citizenship?
Depending on what kind of mistake, we had a client earlier this year file for citizenship and the mistake was discovered and the entire family's green card was voided. This was a Vietnamese family, and it was multiple families. So the father applied for the children, the father and the children, I don't know, the father got it through like F4 and the children all got it together, but they got it too early. USCIS made a mistake. They all got the green card. They've been in the US for like 20 years. At the citizenship, everything was discovered. Void, 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 void. Denial, 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 denial. Luckily, they weren't. Deported. They weren't issued an NTA. They were given the permission to reapply adjustment of status, which is what we did, and then they all got approved. But the new approval is a brand new green card, and they have to re-wait 5 years before they can apply citizenship again. That second part, I don't feel like is right. I feel like if USCIS, you made a mistake, you granted green card too early, you're already penalizing them to refile adjustment of status with 2026 filing fees for like, 10, 15, 20 people. I feel like that is already a big punishment. And then now you're going to make them wait again. They've already been behaving and acting and paying taxes as if they're, but anyways, I'm venting to you. But anyways, if they made a mistake, it is entirely possible for the government to void your green card.
And do you need to be in the US to file the reentry permit?
Yes.
Can you leave while it's being processed?
You can leave while it's being processed, but you need to file in the US.
Does your firm do mandamus?
We do, we can, we prefer to do it if it's a class action. So we do a lot of mandamus over the years. Usually we group at least 5 to 10 people, 10 families together to do one. It saves costs for everyone. It focuses us. It makes the case stronger. It's a win-win for everything, right? So usually we have a lead plaintiff, then we advertise, then we pull everybody together, then we file. That's usually when we do it. And when we usually do it when there's a really strong argument on, government is really messing up somehow, right? Then we do it. We rarely do it for one individual because the cost is too high. Usually the circumstance is just not as strong and it makes the case weaker and the government drags it out because it's just one case. So, but, can we do it? Yes. Do other firms do just one person all the time? Sure. But I just want to give you context of what we do.
So can employers now file an H-1K abroad without paying the fee?
Probably. We haven't done it. We haven't looked into it. But I mean, once the government appeals it, then it's probably going to be on pause, right?
Okay, we'll take one more question, then jump into the success story. My master's is in finance, worked in a bank in Egypt for a year. Is there a strong chance of immigration?
if you were sitting in front of me and you had an employer in the US who really likes you and wants to employ you, friend, family, relative, partner, investor, colleague, partner, doesn't matter. If there's somebody else who is fond of you, who wants to employ you, who you want to work together, and you have that background, I believe the three of us can probably come up with a really good plan for you to get a non-immigrant visa and then a green card. But if you're sitting in front of me and say, "Oh, I don't know anybody in the US. I haven't sent out my resume yet. Nobody has hired me yet." I would say chances of you being able to get a work visa, get a green card to come into the US is very slim.
Okay, I want to jump into our success story. If we have time afterward, we will get to some more questions.
Okay. Before I jump into success story, one last thing to finalize the ICE topic, because I was just about to jump in to talk about the breakdown, right? So again, they got 70 billion last year. This year they just got 70 billion, but 10 billion is their annual budget, which they are underfunded. This 70 billion that they got, they're only getting 30-ish, right, of the 30 billion, and it's supposed to cover 2.5 years. So it's really just their annual budget spread out, and they're not getting that much more. Now, CBP is getting a whole bunch that ICE could potentially use, as well as the technology upgrade that they're going to use. So it is a little bit more than their annual budget, but it is not some crazy number, especially because over the past decade, like I said previously, ICE has been underfunded. They're not funded. They don't have the resources to do what they're supposed to mandated to do. Now, what they do is a different story, right? What they do, you might not agree with. How they do it is probably something that a lot of people are agreeing that they don't like, right? Both Republicans and Democrats don't necessarily like the way they are going about doing certain things. Specifically, the crazy raids and the crazy detentions, right? But again, under Obama's administration deported just as much, if not more, people. So, but there wasn't a crazy outrage under his administration. So it's not so much what they do, it's how they do it, and that's not directly tied to the funding. So that's the 10 billion, and then that's 70 billion for this year. Now, the previous 70 billion that they got last year, the bulk of it is actually going to detention centers, and that's not even directly going to the ICE, right? And then the extra 30 billion is to expand the scope of their operation and hiring staff and building it up. But again, given the past decades of being underfunded with what they have to do, that number somewhat makes sense. I think I just want to focus everybody's attention that the funding is not to fund what people are seeing on the news. You could disagree about how they go about doing certain things. You could disagree on some of the functions. And you can disagree that no oversight is not a good thing. That's all fine. But the price tag of 70 billion last year and this year compared to 10 million, and therefore 140 million is going to complete waste, and it's complete fraud. I don't think that's fair, right? So I think I just want to focus on what the conversation should be about. What should ICE be doing? How should they go about doing it? And what kind of oversight should they have to make our country better? That should be the focus of the conversation, not just a simple 140 million versus 10 million, unjust, unfair, this is crazy. I don't think that's right. Okay, now we're going to jump into the success story. This is a very interesting one. Oops, I don't have it here. Oh, there it is. Okay. This case is about a Child Status Protection Act. This girl is 30 years old now and came into the US as a tourist and filed for adjustment. Now, how does that whole thing work? Well, the parents got the green card almost a decade ago, okay? But she aged out back then. The consulate denied her because she aged out. The CSPA law couldn't give her the green card because she was too old. And then in 2023, a memo came out that allowed her to be able to use the new Child Status Protection Act to freeze her age to bring it under 21. We filed the case in 2024, and just last week, the case got approved without an interview, without a request for evidence. And I want to walk you through some of the details of it so you could kind of quickly compare. Now, we all know that the CSPA law, the new one that's been implemented in 2022 and 2023, has now been revoked in 2025. And so you can no longer do this unless you have some extraordinary reason, which is getting harder and harder to come by. But nonetheless, this family was able to do it. And I just kind of want to walk you through the timeline, right? So they filed their EB-5 investment case in 2015 of February. It was approved 2017 of February. It took 2 years to adjudicate their investment. The child was born in 1997, so 29, 30 years old now. They paid for all the NVC fees in 2020, but in 2022, when she went to the interview, she got denied because she aged out. So 2022, right? She was already like 23 years old at that time, right? Or no, more than that. She was 25 years old at the time. So sorry, CSPA, even if we shrink it back down, you're still over 21. Game over. The child left the United States because before she was studying on an F1 international student visa, left the US. In 2024, came back to the US as a tourist. In July of 2024, we filed the CSPA adjustment of status following to join her parents' green card, which they got almost a decade ago. Once that was filed, the combo card was approved in March of 2025, and last week, June 2026, the green card was mailed to her. The old CSPA law didn't allow her to use a different schedule for the priority date. The new law allowed it. The new memo, not law, but the new memo by USCIS allowed it. And that created this opening from 2023 all the way until 2025, where we were able to file hundreds of cases to preserve their status, because all of these EB-5 investors, all of their children who aged out because the EB-5 just took too long, most of these investors wanted the green cards for their children. They don't really want the green card for themselves, but to give their children a better future. Their children was a teenager when they did the investment. By the time everything got approved and they got the green card, went to the interview, it was already too late. They're already 21, 22, 23, 24, 25. And now it seems like, okay, the parents got the green card, but they don't even want to be here, and the children have to be back. So it became this awkward situation where parents are here with the green card, filing reentry permits, going back to Asia to be with their kids, and the kids can't come to the US because the parents already got the green card, but the kids can't get the green card. So it's just this big mess. Most of our cases, the children wanted to stay in the US, so they got the F1 visa, they got the H1B, they're still in the US somehow, some way. Now the parents are with them. Or the parents left, doesn't matter, right? But we were able to file the following to join. Some parents already abandoned the green card. They can't do the following to join. So that was really sad too, right? They found out their kids can't get it, so they're like, we don't want it, so they abandoned it. But then 2023 happens where the children could get it, but they've already abandoned it, so it's too late. But between 2023 to 2025, that was this magic window where the CSPA memo, it wasn't even a law, it was just a memo. And arguably, it was like one of those, intern decisions, kind of, but like, why do we have two schedules? Why don't we apply earlier? Why don't we let them use CSPA? It just makes much more sense. So they polished it out, sent it out. They might not have had EB-5 even on their mind when it went out, but it helped hundreds of EB-5 investors and their children. And this is the latest case that we got the approval for, right? We filed it in July of 2024, and now 2 years later, the case is approved. The client is here. The green card's in hand. It's just like multiple miracles all happening all at once. I'm just so happy for them. And I don't know, the takeaway from this is just like, you never know what memo is going to be super important. You don't know what immigration policy, world affairs is going to affect the process, right? But as long as you're like paying attention, and when there is an opening and you do it well, It might take 2 years. We didn't expect it to take 2 years. We were hoping it will take like a year. Like, you know, I mean, we prepare a case, we file it. It took 3 months to prepare the CSPA case, we file it. You know, I mean, it took less than 3 months. It probably took 2 months, right? But still, like, I'm just so happy the clients got it. This was Amy's team in China. They worked really hard on it, and we just want to celebrate with everyone. So that was a CSPA. And what makes it more important now is the fact that the kid came as a tourist visa to apply for adjustment of status. And this new memo makes that much more difficult, right? And so if somebody wanted to do that now, it would be even more difficult compared to back then, you know? So they got that golden opportunity to do it. They grabbed it, and then now they got the green card, right? That's what the parents wanted back in 2015. Now this, you know, almost 10 plus years later. So happy for them. If you guys have any questions about CSPA, about, you know, anything immigration related, now again, we don't do asylum cases, we don't do removal defense, but, you know, these are things that we kind of focus on. Feel free to give us a call, schedule a consultation. We would love to help you. Okay, take care. Bye-bye.
Okay, and that is our time for today. Thank you, everyone. We will... Oh, do you want to talk about Ayla, our next week?
Oh, yes. So, announcement. Next week, Wednesday, Thursday, Friday, and Saturday, we will be doing lives every single day. It'll be an hour each. We'll have guest speakers on some of them. We'll be talking about success stories. We'll talk about news. We're going to Ayla in San Diego, and that's where all the immigration lawyers around the country, around the world gathers to discuss, to learn, and I'm speaking at one of the panels. So I'm really excited about this. We go almost every single year. We've been going for a long, long time now. We always learn a lot of big new updates. So we have a lot to share. This is the first time we're going to do 4 lives. Usually when we go, we just do 1, but we're going to be doing 4. And again, we'll be taking live questions as well. So see you guys there. Take care. Bye-bye.
So our first Q&A on Wednesday at 7 p.m. PST. We will answer more questions there. I'm sorry we couldn't get to everyone's today.
Yeah.
Okay.